Case Closed, the podcast helping you make sense of the law one episode at a time. I'm Jade, and today we're exploring what happens after a civil court decision when one side isn't happy with the outcome. Today's topic is civil court appeals. So you've gone through the trial, a decision's been made, but somebody's not happy. Maybe the compensation awarded seems too low, or they think the judge got it wrong. In that case, the losing party may be able to appeal the decision, but it's not just a free do-over. Let's break it down. An appeal is about legal arguments, not simply saying we don't like the result. New evidence is rarely heard. The focus is on how the law was applied in the original decision. Appeals go to a higher court and it has to happen fast, usually within 21 days of the original judgment. Legal costs do increase, especially as lawyers are typically needed to argue the appeal. The appeal court might agree with the original decision, reverse it, or change the amount of compensation awarded. Where do you go if you're appealing a decision made in the county court? Well, that depends on who made the decision. If it was a district judge, the appeal goes to a circuit judge, but still within the county court. If the circuit judge made the original decision, then the appeal goes up to a high court judge in the relevant division. This could be the King's Bench, Chancery, or Family Division. In exceptional cases, the appeal can go directly to the Court of Appeal. That's if the case raises a point of principle or a complex legal issue, and the Court of Appeal agrees to hear it. If the original decision was made by a high court judge, the appeal will usually go to the Court of Appeal. But what if that isn't the end of the road? A further appeal can be made to the Supreme Court, but this isn't automatic. The Court of Appeal must first grant permission, and this is only done if there's a point of law of general public importance. And finally, in rare situations, there is something called a leapfrog appeal. That's where the appeal goes directly from the High Court to the Supreme Court, skipping the Court of Appeal altogether. This is only allowed if the court raises national importance or the legal issues involved are serious enough to justify skipping a level. So let's summarise the essentials. Appeals are legal arguments, not disagreements with a result. They must be made within 21 days and usually only go up one level in the court hierarchy. From the county court, it goes from a district judge to a circuit judge, or a circuit judge to a high court judge, or in rare cases, it can go on to the Court of Appeal. From the High Court, cases are appealed to the Court of Appeal and possibly the Supreme Court if permission is granted. In rare circumstances, cases can leapfrog straight from the High Court to the Supreme Court. And that's a wrap on today's episode of Case Closed. Now you know what happens if someone challenges a civil court decision. It's not the easiest of topics to get your head around. Next time we'll be diving into tribunals, so stay tuned if you want to keep building on your legal knowledge. If you're enjoying the podcast, give it a follow and share it with somebody else who's revising. Until next time.